Welcome to Immigration Quicktake. This is Jessica Eyes with the American Immigration Lawyers Association. While the Senate took a comprehensive approach to immigration reform, the House approach has been markedly different, with the House Judiciary Committee taking up 4 separate immigration-related bills. Amongst those, one is causing widespread concern, the Strengthen and Fortify Enforcement Act, or the SAFE Act. Here to discuss this bill is the director of the Immigration Policy Center, Mary Giovagnoli. Mary, can you give us a rundown on the SAFE Act?
Sure. The SAFE Act is an enforcement-only bill in that it only looks at immigration through an enforcement lens. It essentially is another version of attrition through enforcement, so that you're making life so difficult for people that they must leave the country. And it does that in a variety of ways. It would overturn Arizona v. U.S., so it actually would allow states and localities to create their own immigration laws and to require DHS to support them by detaining individuals, by entering into 287G agreements at the request of the state or the locality. It would make unlawful presence a criminal act. It would expand the universe of and reasons for which people could be detained mandatorily, including allowing unlimited indefinite detention for individuals. And that's just sort of the top line items. It really is trying to recalibrate the whole immigration enforcement system to put all the authority in the hands of state and local governments rather than the federal government.
Thank you. And what aspects of this bill cause you the most concern?
I think it's that mindset, frankly, that it switches the emphasis from the federal government to state and local entities in terms of enforcing immigration law. And what's really disturbing about that, of course, is that we've already seen that that doesn't work. In fact, U.S. v. Arizona was all about that immigration and immigration enforcement are a federal issue, and that we need to do it comprehensively and across the board, and not have a patchwork of 50 different states with 50 different rules. So it's really turning back the clock and trying to not only sort of maintain the status quo, but move us backward in time, when I think the Supreme Court very effectively said that's not the right position for both in terms of the law and in terms of the policy that the government should be taking. I think the other thing that's really critical, of course, is that it would criminalize any kind of unlawful presence. And so many people have called this the son of Sensenbrenner, meaning that it is likely to create the same kind of, reaction from people if it were to pass that we saw in 2005 when the Sensenbrenner bill also criminalized unlawful presence and visa overstays.
Do you foresee this bill being taken up on the floor?
I think that we could see it come to the floor, but I think it's fairly doubtful that it could pass, because it frankly is so extreme that I think that there will be Republicans who break from the pack to vote against it. I also think the other thing that we have to bear in mind is that if it were to come up and if it were to be offered as one of the only options in the House for trying to get to immigration conference with the Senate in the past Senate bill, I think that most advocates would say this is too much to stomach. No matter how much we want full reform and a path to citizenship, if the price is something as high as the SAFE Act, I think you're going to find a lot of people backing away from any kind of deal like that.
Thank you, Mary, for joining us. For the rest of you, please stay tuned for more updates through Immigration Quicktake with the American Immigration Lawyers Association.